What are the key legal differences between medical negligence and malpractice, and how does this distinction impact a physician's liability? Answer: negligence refers to the failure to provide the standard of care that a reasonably competent medical professional would provide in a similar situation, leading to harm or injury to the patient. It involves unintentional acts or omissions. Malpractice, on the other hand, involves negligence but with an additional element of intent or egregious error. In malpractice cases, the physician's actions deviate significantly from the accepted medical standards, often indicating recklessness or willful misconduct. Key impact on liability. In cases of negligence, liability arises from carelessness or unintentional error, which may result in civil penalties or compensation claims, but is less likely to involve criminal charges unless gross negligence is proven. In malpractice, because of the intentional or egregious nature of the actions, the physician may face both civil and criminal charges, more severe disciplinary actions from medical boards, and higher compensation payouts in lawsuits. Relevant laws. Civil code provisions on negligence, medical malpractice laws, and professional standards set by the National Medical Council guide how these distinctions affect liability. According to legal standards, what elements must be present for a physician to obtain valid informed consent from a patient? Answer: to obtain valid informed consent, the following elements must be satisfied. Disclosure: the physician must provide the patient with all relevant information regarding the diagnosis, proposed treatment, potential risks and benefits, alternatives, including no treatment, and possible outcomes. Competency: the patient must have the mental capacity to understand the information and make a voluntary decision. If the patient lacks competency, a legal representative, such as a guardian, must provide consent. Voluntariness: the patient's consent must be given freely without any form of coercion or undue influence from the healthcare provider. Comprehension: the patient must fully understand the information provided. This may require the physician to adjust communication based on the patient's level of understanding, language proficiency, or cultural background. Relevant law. The legal requirement for informed consent is based on civil code principles and reinforced by court rulings, such as the Bolam test in medical negligence cases, which evaluates the standard of disclosure based on what a reasonable body of medical professionals would consider adequate. Dr. Martinez is treating a 75-year-old patient, Mr. Jensen, who has early-stage dementia. Mr. Jensen insists on making his own medical decisions, but his cognitive tests show significant impairment. What legal and ethical steps should Dr. Martinez follow to ensure Mr. Jensen receives appropriate care? Answer: assessment of competency. Dr. Martinez should first assess Mr. Jensen's cognitive abilities in detail to determine whether he is legally competent to make medical decisions. This involves both clinical evaluations and, if necessary, legal intervention to assess competency through the courts. Involve legal representatives. If Mr. Jensen is deemed incompetent, Dr. Martinez must engage Mr. Jensen's legal representative or court-appointed guardian to make decisions on his behalf. This must be done while respecting Mr. Jensen's autonomy as much as possible, involving him in discussions about his care. Document the process. It is crucial that Dr. Martinez documents all steps taken in assessing competency, including the patient's cognitive tests and consultations with family members or legal representatives. Legal framework. The legal basis for assessing and determining competency comes from the guardianship and competency laws, which outline the procedure for appointing a guardian or legal representative when a patient lacks decision-making capacity. What are the legal responsibilities of a physician in documenting patient encounters to minimize the risk of litigation? Answer: physicians must follow strict documentation practices to reduce the risk of litigation. The key responsibilities include accurate and timely documentation. All patient encounters, including clinical findings, diagnosis, treatment plans, and patient communications, should be documented in real time. Delayed or incomplete records may lead to issues in court, as they can be construed as negligence. Clear and detailed notes. The records must be clear, objective, and detailed enough to reflect the physician's reasoning process. Any deviation from standard care should be justified with appropriate explanations. Consent forms. Properly signed and witnessed informed consent forms must be kept as part of the patient's medical record. This is especially important for high-risk procedures or treatments. Communication records. All communications with the patient and their family, including phone calls and emails, should be documented, especially if there are disagreements about the treatment plan. What are the steps a physician should follow when serving as an expert witness in a medical litigation case? Answer: when a physician is called to serve as an expert witness, they must follow these steps. Review of case files. The physician must thoroughly review all medical records, reports, and relevant documents related to the case to form an objective opinion. Pre-trial preparation. The expert witness should work with legal counsel to prepare for potential cross-examination and anticipate the opposing counsel's challenges to their testimony. Provide objective testimony. The physician's testimony must be impartial and based solely on medical facts without any bias toward the patient or defendant. The testimony should explain whether the standard of care was met or breached and how this impacted the outcome. Adherence to rules of evidence. The physician must adhere to the rules of evidence which govern the admissibility of expert testimony. This includes being qualified based on education, experience, and specialized knowledge. Relevant law. The role of an expert witness is defined by the rules of civil procedure, particularly in how expert opinions are presented and evaluated in court. What are the legal and ethical challenges involved in treating patients with diminished capacity, and how can physicians navigate these issues? Answer: when treating patients with diminished capacity, physicians face several challenges. Determining capacity. The first challenge is assessing whether the patient has the mental ability to make informed decisions. This involves not just clinical judgment, but may also require legal input such as a court-appointed competency assessment, ethical duty to respect autonomy. Even if the patient's capacity is diminished, physicians must still strive to involve the patient in decision-making as much as possible, balancing autonomy with the need for appropriate care. Involvement of guardians or legal representatives. In cases where the patient is incompetent, decisions must be made by a legal representative. The physician must work closely with this representative to ensure that the patient's best interests are served. Documentation. Every step, including the assessment of capacity and communications with family or legal representatives, must be thoroughly documented to prevent future legal disputes. Relevant law. The Legal Capacity Act outlines procedures for determining a patient's decision-making abilities and appointing legal guardians when necessary. In the context of medical litigation, what are the procedures for serving as an expert witness, and what are the consequences of providing misleading testimony? Answer: role of expert witness. Physicians who serve as expert witnesses must provide objective, fact-based testimony regarding whether the standard of care was met. They are responsible for interpreting medical facts and presenting them in a way that helps the court understand complex medical issues. Consequences of misleading testimony. If an expert witness knowingly provides misleading or false testimony, they can face severe legal consequences, including charges of perjury. This can lead to criminal prosecution as well as civil penalties such as fines or imprisonment. Ethical obligations. Physicians acting as expert witnesses are bound by ethical guidelines that require honesty and impartiality. Providing false testimony can also lead to disciplinary actions from medical licensing boards, including suspension or revocation of the physician's license. Relevant law. The legal consequences of perjury are governed by criminal law, while professional consequences are regulated by the medical licensing statutes and ethical guidelines set by the National Medical Council. How can effective risk management strategies minimize legal exposure for physicians in clinical practice? Answer: effective risk management strategies are essential for minimizing legal exposure. These strategies include adherence to guidelines. Physicians should follow established clinical guidelines and protocols to ensure that they meet the standard of care expected in their specialty. Proactive communication. Open and honest communication with patients about their conditions, treatment options, and potential risks is critical. This helps build trust and can prevent misunderstandings that may lead to litigation. Continuous education. Physicians should engage in ongoing medical education to stay updated on best practices and evolving medical standards. This reduces the likelihood of errors caused by outdated knowledge. Comprehensive documentation. Keeping detailed, accurate medical records is vital for defending against potential lawsuits. Proper documentation demonstrates that the physician acted in a manner consistent with the standard of care. Relevant law. Risk management practices are governed by tort law, which deals with civil wrongs and liability in medical negligence cases. Dr. Patel is performing surgery on a patient, MS Reynolds, who develops complications during the procedure. Dr. Patel did not disclose this particular risk during the informed consent process. Afterward, MS Reynolds considers filing a lawsuit. What legal principles will determine whether Dr. Patel is liable for medical negligence? Answer: in this case, Dr. Patel's liability will be evaluated based on the following legal principles. Duty of care. Dr. Patel had a duty to provide care that met the standard expected of a reasonably competent surgeon in similar circumstances. Breach of duty. The failure to disclose the specific complication could be considered a breach of the informed consent doctrine if it is determined that a reasonable patient would have wanted to know about this risk before deciding to undergo the surgery. Causation. MS Reynolds must prove that the failure to disclose the risk directly caused her injury or harm. This means showing that had she been informed, she might have chosen not to proceed with the surgery. Damage. MS. Reynolds must demonstrate that she suffered actual harm as a result of the complication. Relevant law. The legal standards for informed consent and medical negligence are derived from case law and civil liability statutes in healthcare. What role do ethics committees play in resolving medical disputes between physicians, patients, and families, and how does this process work in practice? Answer. Ethics committees are instrumental in resolving conflicts that arise in complex medical cases. Their role includes facilitating communication. Ethics committees help mediate discussions between physicians, patients, and families when there is disagreement over treatment decisions. They provide a neutral platform for open dialogue, providing ethical guidance. The committee offers advice on the ethical principles involved, such as patient autonomy, beneficence, and justice, ensuring that the best ethical decision is made in the patient's interest. Advisory role. While ethics committees do not have legal authority, their recommendations often carry significant weight in the decision-making process. Their involvement can prevent disputes from escalating into legal battles. Relevant guidelines. The ethical guidelines for clinical ethics committees provide the framework for how these committees operate, ensuring that all parties have a fair and just process for resolving disputes. A physician receives a request from a third-party insurance company asking for a patient's complete medical records for the purpose of processing a claim. The physician is aware that the patient has a sensitive condition disclosed in the records. What ethical and legal steps should the physician follow before disclosing this information? Answer. The physician must adhere to the principles of patient confidentiality and data protection laws, particularly under the GDPR and French law on patient data protection. Steps to follow. Obtain explicit patient consent. The physician should inform the patient of the request and obtain voluntary, informed, and specific consent for the disclosure of their medical records. Limit disclosure. The physician should ensure that only the relevant information necessary for the claim is shared, avoiding unnecessary exposure of sensitive medical details. Consider exceptions. If the patient refuses to give consent, the physician must assess whether any legal exceptions apply, duty to warn or public health reporting, which may justify sharing the information without consent. In this case, no such exceptions appear to be present. Legal requirements. The physician must comply with the GDPR guidelines, ensuring that any disclosure to third parties is lawful, transparent, and limited to the data's intended purpose. Failure to protect patient confidentiality can lead to legal consequences, including disciplinary actions from the Order of Physicians or civil liability under data protection laws. Explain the principles of autonomy and beneficence in medical ethics and how a conflict between these two principles may arise in practice. Answer. Autonomy refers to the patient's right to make informed decisions about their own healthcare. It emphasizes respect for individual choices, requiring the physician to provide patients with all necessary information to make an informed decision without coercion. Beneficence is the physician's duty to act in the best interest of the patient, promoting well-being and preventing harm. Physicians must ensure that the treatment provided is aimed at improving the patient's health and quality of life. A conflict between autonomy and beneficence may arise in situations where a patient's choice contradicts what the physician believes to be in their best interest. For instance, if a patient refuses a life-saving treatment, autonomy, the physician may feel ethically compelled to encourage the patient to accept the treatment. Beneficence. Resolving such conflicts requires careful negotiation, ensuring the patient's values and preferences are respected while also providing professional guidance. Dr. Laurent is treating Mr. Dupont, an 80-year-old patient with advanced dementia who is no longer able to make informed decisions regarding his medical care. Mr. Dupont's family insists on continuing aggressive treatment, even though Dr. Laurent believes palliative care would be more appropriate. What are Dr. Laurent's ethical responsibilities in this situation, and how should he proceed? Answer. Dr. Laurent must balance the principles of non-maleficence, doing no harm, and beneficence, acting in the patient's best interest, with the ethical consideration of respecting family wishes and involving them in medical decisions. Steps to follow. Assess decision-making capacity. Since Mr. Dupont cannot make informed decisions, Dr. Laurent should ensure that the family understands the patient's prognosis and the potential benefits and burdens of continuing aggressive treatment. Discuss alternatives. Dr. Laurent should communicate clearly with the family, explaining the rationale for recommending palliative care, which focuses on comfort and quality of life. Advanced directives. If Mr. Dupont has any advanced directives or previously expressed preferences about his end-of-life care, Dr. Laurent must follow those wishes. Ethics consultation. If the family remains opposed to palliative care, Dr. Laurent may involve an ethics committee or mediator to help resolve the conflict while upholding his professional integrity and ensuring the best possible care for Mr. Dupont. What legal consequences can a physician face for failing to obtain proper informed consent before performing a medical procedure? Answer: failing to obtain valid informed consent exposes the physician to significant legal and ethical consequences. Civil liability. The patient may sue for medical malpractice or negligence if they suffer harm as a result of a procedure performed without proper consent. Compensation could cover damages related to pain, suffering, and financial losses. Criminal liability. In certain cases, performing a procedure without consent may be considered battery or assault, especially if the patient experiences significant harm. Disciplinary action. The physician may face sanctions from the Order of Physicians, including fines, suspension, or revocation of their medical license. Professional reputation. A breach of informed consent can damage the physician's professional standing and trust within the medical community as well as with patients. Informed consent is a fundamental ethical and legal requirement, and failure to obtain it can have wide-ranging consequences. Under what circumstances can a physician breach patient confidentiality, and what legal justifications are required for such an action? Answer: a physician can breach patient confidentiality in specific legally justified situations. Duty to warn. If a patient poses a direct and imminent threat to themselves or others, e.g., suicidal ideation or planning to harm someone, the physician may be obligated to report this to the relevant authorities or individuals at risk. Public health reporting. In cases of communicable diseases that pose a risk to the public, e.g., tuberculosis, COVID-19, physicians are legally required to report the patient's condition to public health authorities under French law. Legal proceedings. A court may compel the disclosure of patient records during legal proceedings if deemed necessary for the administration of justice. Child or elder abuse. Physicians are mandated to report any suspected abuse or neglect of vulnerable individuals, including children and the elderly. Any breach of confidentiality must be done with caution, ensuring it complies with GDPR and national legal frameworks, and is only to the extent necessary to fulfill the legal obligation. What ethical and legal guidelines govern the management of conflicts of interest between physicians and pharmaceutical companies? Answer: conflicts of interest between physicians and pharmaceutical companies are governed by several ethical and legal guidelines. Disclosure of conflicts. Physicians must disclose any financial ties or incentives they receive from pharmaceutical companies that may influence their clinical decision-making. Prescribing practices. Physicians are ethically obligated to base their prescribing decisions on evidence-based medicine and the best interest of the patient, not on financial incentives from pharmaceutical companies. Acceptance of gifts. Accepting gifts, even small ones, from pharmaceutical companies can create a perception of bias and is generally discouraged. Large gifts or payments are prohibited as they may directly influence medical judgment. Legal frameworks. In France, physicians must adhere to laws prohibiting undue influence from pharmaceutical companies, and any violation can result in penalties, including sanctions from the Order of Physicians. Managing conflicts of interest is essential for maintaining professional integrity and patient trust. Dr. Chevalier has a close personal friendship with a representative from a medical device company. The representative offers Dr. Chevalier a free, all-expenses-paid trip to a conference in exchange for promoting their latest product to patients. What should Dr. Chevalier do in this situation, and what ethical guidelines are at play? Answer: Dr. Chevalier is facing a potential conflict of interest. Ethical guidelines and professional standards emphasize the following: rejecting undue influence. Dr. Chevalier must refuse any gifts or financial incentives that could compromise his professional integrity or be perceived as influencing his medical decisions. Transparency. Even if Dr. Chevalier believes that the product is beneficial to his patients, accepting such a significant gift would create a conflict of interest. He should disclose any financial or personal relationships that may bias his recommendations. Professional integrity. Dr. Chevalier must ensure that all treatment decisions are made based on evidence-based medicine, prioritizing the well-being of his patients over personal benefits. Failure to manage this conflict could result in ethical violations and potential disciplinary actions from the Order of Physicians. Discuss the legal and ethical considerations for physicians involved in end-of-life care decisions, particularly regarding palliative sedation and the withdrawal of life-sustaining treatment. Answer: physicians involved in end-of-life care must navigate several legal and ethical considerations. Palliative sedation. This is ethically acceptable when used to relieve intractable suffering in terminally ill patients, provided it is in line with the patient's wishes or advanced directives. The sedation must not be used with the intention to hasten death, as that would cross into euthanasia. Withdrawal of life-sustaining treatment. Physicians may withdraw or withhold treatments, e.g., ventilators or feeding tubes, when such interventions are no longer in the patient's best interest and only prolong suffering. This decision should be guided by the patient's wishes, either expressed directly or through an advanced directive. Legal framework. Euthanasia and assisted suicide remain illegal in France, but palliative care and the withdrawal of life-sustaining treatment are permitted under strict ethical guidelines as outlined in French end-of-life care laws. Physicians must ensure that all decisions respect patient autonomy, are aligned with legal requirements, and prioritize patient comfort and dignity. Explain the principle of justice in medical ethics and its relevance in healthcare resource allocation. Answer: the principle of justice in medical ethics refers to fairness in the distribution of healthcare resources and the treatment of patients. It emphasizes that all individuals should receive equitable access to medical care and that healthcare professionals must strive to eliminate disparities based on race, socioeconomic status, gender, or other factors. Relevance in healthcare resource allocation. Equitable access. Justice requires that all patients have equal access to healthcare services, regardless of their background or financial means. This principle is particularly crucial in public health and during crises, e.g., pandemics, where resources may be limited. Fair distribution of resources. Healthcare providers must make decisions on resource allocation that are fair and transparent. This includes prioritizing care based on medical need rather than personal or social factors. Addressing disparities. Physicians and healthcare organizations should work to identify and address systemic barriers that contribute to health disparities, ensuring that marginalized populations receive the care they need. Dr. Morau is faced with a situation where a hospital has a limited supply of a life-saving medication and 2 patients need it urgently. Patient is a 30-year-old parent with young children, while patient B is a 70-year-old with several comorbidities. How should Dr. Morau ethically approach this dilemma? Answer: in this situation, Dr. Morau should approach the dilemma by considering the ethical principles of justice, beneficence, and non-maleficence. Assess medical need, evaluate both patients' conditions to determine who is more likely to benefit from the medication based on clinical criteria, consider the potential for recovery and overall prognosis. Fair allocation, apply a transparent and fair process for allocating the medication. This might include triaging based on urgency, likelihood of survival, and potential quality of life after treatment. Consult policies and guidelines. Refer to hospital policies regarding resource allocation during shortages, which may provide guidance on how to handle such situations ethically. Involve an ethics committee. If necessary, Dr. Morau may consult with an ethics committee for additional perspectives and support in making a fair decision. Communicate with patients and families. After decision is made, communicate clearly and compassionately with both patients and their families about the rationale behind the allocation decision, emphasizing that it was made based on clinical criteria rather than personal factors. In the context of French healthcare, explain the differences between assurance maladie, public healthcare, and private insurance. How do they interact, and what are the implications for patients and physicians? Answer: assurance maladie is the national health insurance system in France that provides universal coverage to all legal residents. It is financed through payroll taxes and provides coverage for a broad range of healthcare services. Patients are reimbursed for a percentage of their healthcare expenses, with the amount varying depending on the service, usually 70% for general medical consultations and 80% for hospitalization. Private insurance, also known as mutuals or complementary health insurance, supplements the coverage provided by assurance maladie by reimbursing the remainder of healthcare costs, such as co-payments and services not fully covered by the public system. Private insurance is optional but widely used. For physicians, this dual system affects billing. Physicians may operate within the convention system, accepting the state-regulated tariffs, or they may operate partially or entirely outside it, charging higher fees that are only partially reimbursed by assurance maladie. Dr. Dupont, a recently licensed physician in France, has received an offer to work in a private clinic. The clinic follows a tariff structure that exceeds the official rates set by assurance maladie. What legal and ethical considerations should Dr. Dupont be aware of before accepting the offer? Answer: Dr. Dupont must consider the following legal and ethical obligations. Convention versus non-convention status. If he joins a private clinic with tariffs exceeding those set by assurance maladie, he will likely be classified as a Sector 2 doctor, allowing for extra billing dépassement d'honoraires. This must be clearly communicated to patients who may face low reimbursement rates. Transparency with patients. Ethically, Dr. Dupont must ensure that patients are fully informed about the costs and the extent of reimbursement before treatment. Obligations to the public system. Even if practicing in the private sector, he remains under the jurisdiction of the National Council of the Order of Physicians and must uphold the ethical standards outlined, including accessibility to care and avoidance of excessive fees. Regulation and oversight for such practices are in place to ensure that while extra billing is permitted, it must not compromise patient care or lead to financial discrimination. Describe the role and functions of the National Council of the Order of Physicians in regulating the medical profession in France. How does this body ensure ethical practice among its members? Answer. The National Council of the Order of Physicians, Conseil National à l'Ordre des Médecins, plays a critical role in overseeing the medical profession in France. Its main functions include licensing and registration, ensuring that physicians meet the required qualifications to practice, ethical oversight. It monitors and enforces the ethical code governing medical practice, ensuring that physicians adhere to principles of patient care, confidentiality, and professional integrity. Disciplinary actions. The Council has the power to investigate complaints, conduct hearings, and impose sanctions on physicians who violate ethical or legal standards. Advisory role. It also serves as an advisory body offering guidance to both physicians and policymakers on matters related to healthcare practice and ethics. The Council ensures that all physicians uphold the medical code of ethics, which includes obligations such as prioritizing patient welfare, maintaining confidentiality, and providing equitable care regardless of the patient's socioeconomic status. MS. Leclerc, a foreign-trained physician, seeks to practice medicine in France. She has completed her medical training in a non-EU country and has applied for recognition of her qualifications. What steps must she follow to be licensed to practice, and what legal challenges might she face? Answer. MS. Leclerc must navigate the following process. Equivalency recognition. She must apply for recognition of her qualifications through the Ministry of Health, which assesses foreign diplomas based on equivalence to French medical education standards. Non-EU physicians often face a more rigorous process than EU physicians. Examination requirements. Depending on the evaluation, she may need to pass specific exams or complete additional training in a French institution. Registration with the National Council of the Order of Physicians. After qualification, she must register with the Conseil National à l'Ordre des Médecins, which oversees all licensing and ensures ethical practice. Legal challenges may include language barriers, meeting French clinical standards, and navigating the bureaucratic process for recognizing non-EU qualifications. Explain the role of regional health agencies, agencies régionales Saint or ARS, in the coordination between primary care and hospital care in France. Answer. The ARS play a critical role in the coordination of healthcare across regions in France. Their functions include healthcare planning and oversight. They are responsible for managing healthcare delivery in each region, ensuring that both primary care, general practitioners, and hospital care specialists are integrated. Resource allocation. They ensure that healthcare resources, such as medical equipment, personnel, and facilities, are distributed efficiently to meet the needs of the population. Public health campaigns. They coordinate public health initiatives like vaccination drives and preventive screenings, ensuring that primary care physicians and hospitals work together. Crisis management. During health emergencies, the ARS coordinate the response efforts across hospitals, ensuring that primary care providers are informed and involved in the management of patients. Discuss the obligations of a physician in terms of continuing professional development. CPD in France. What are the legal requirements, and how does the National Council of the Order of Physicians enforce compliance? Answer. In France, all practicing physicians are legally required to engage in continuing professional development CPD to maintain their medical license. The key legal obligations include annual CPD requirements. Physicians must complete a set number of CPD hours every year, participating in courses, workshops, or seminars that are accredited by recognized CPD providers. CPD credits. Physicians must earn CPD credits, which are then reported to the National Council of the Order of Physicians. These credits are used to demonstrate ongoing professional education. Sanctions for non-compliance. If a physician fails to meet CPD requirements, the National Council can issue warnings and in severe cases suspend the physician's license until they fulfill the necessary educational hours. The National Council actively monitors compliance through regular audits and the mandatory reporting of CPD activities. Explain the significance of patient access to healthcare services in France. What legal and ethical obligations do physicians have regarding patient access and the reimbursement policies? Answer: patient access to healthcare services is a fundamental principle of the French healthcare system, grounded in both legal and ethical frameworks. Key obligations include legal framework. According to the French Code La Santé Publique, every patient has the right to access healthcare services without discrimination based on their socioeconomic status, geographic location, or health condition. Ethical obligations. Physicians are ethically obliged to prioritize patient welfare and facilitate access to care. This includes being aware of the reimbursement policies of assurance maladie and private insurance systems and informing patients about their entitlements and any potential out-of-pocket costs. Reimbursement policies. Physicians must ensure they understand the reimbursement procedures of both public and private systems to provide accurate information to patients regarding what will be covered. Equity in care. Physicians should strive to provide equitable care, avoiding practices that might limit access based on financial considerations. This includes transparency about costs and payment options for services. Dr. Martin is a general practitioner who has noticed an increase in patients requesting vaccinations due to a recent outbreak of a preventable disease in his region. He is unsure how to coordinate with local health authorities to address this public health issue. What steps should Dr. Martin take to engage with regional health agencies and implement a vaccination campaign effectively? Answer: Dr. Martin should take the following steps. Contact the ARS. Dr. Martin should reach out to the local agents Regional San ARS to inform them of the increase in vaccination requests and seek guidance on best practices for vaccination campaigns. Collaboration with public health officials. He should collaborate with public health officials to assess the situation, gather data on vaccination rates in the community, and understand the target population for the campaign. Utilize public resources. The ARS may provide resources for public health campaigns, including informational materials and access to additional healthcare personnel for vaccination drives. Coordinate with other providers. Dr. Martin should communicate with other local healthcare providers to ensure a coordinated response and share resources and strategies for outreach to increase vaccination rates. Engage the community. He should consider organizing community outreach programs to educate the public about the importance of vaccinations, addressing any concerns or misconceptions they may have. What are the key legal instruments and guidelines that govern public health policies in France? Discuss how these instruments facilitate the development and implementation of health regulations. Answer: the key legal instruments and guidelines governing public health policies in France include Code La Santé Publique. This comprehensive legal code outlines the framework for public health in France, detailing the responsibilities of healthcare providers, regulatory agencies, and patients. It covers various aspects of public health, including disease prevention, health promotion, and management of health emergencies. Public Health Law of 2004. This law established the framework for public health policy focusing on prevention and health promotion. It emphasizes the role of regional health agencies as in coordinating public health initiatives and the obligation of healthcare professionals to engage in public health activities. National Health Strategy. The French government develops periodic national health strategies that outline key priorities, objectives, and actions to improve public health. These strategies are informed by data and research, ensuring that policies address current health issues effectively. Regulatory frameworks for specific health issues. Various regulations address specific public health concerns, such as vaccination requirements, food safety standards, and control of infectious diseases. These regulations facilitate the implementation of health policies by providing detailed guidelines for healthcare providers and regulatory agencies. Collaboration with international health organizations. France works with organizations such as the World Health Organization, WHO, and the European Centre for Disease Prevention and Control, EC, to align its public health policies with international standards and best practices. Through these legal instruments, France establishes a clear framework for public health governance, facilitating the development, implementation, and monitoring of health regulations aimed at improving the health of its population. Discuss the role and function of the National Council of the Order of Physicians, Conseil National à l'Ordre des Médecins, in maintaining ethical and professional conduct among physicians in France. What specific regulatory powers does it hold? Answer: the National Council of the Order of Physicians, CNOM, plays a crucial role in ensuring ethical and professional standards among physicians in France. Its functions and regulatory powers include oversight and regulation. The CNOM is responsible for regulating the practice of medicine in France, ensuring that physicians adhere to the legal and ethical standards outlined in the Code de la Santé publique and other relevant legislation. It has the authority to investigate complaints against physicians and impose disciplinary actions when necessary. Licensing and registration. The CNOM oversees the licensing and registration of physicians, ensuring that only qualified individuals can practice medicine in France. This includes verifying credentials, educational background, and compliance with continuing medical education (CME) requirements. Guidance on ethical conduct. The CNOM publishes guidelines and recommendations on ethical practices, helping physicians navigate complex ethical dilemmas in their daily practice. These guidelines address issues such as patient confidentiality, informed consent, and professional relationships with patients and colleagues. Promoting professional development. The CNOM encourages ongoing professional development and education among physicians, requiring participation in CME programs to maintain licensure. This fosters a culture of continuous learning and improvement within the medical profession. Advocacy and policy development. The CNOM serves as an advocate for the medical profession, engaging with government agencies, healthcare organizations, and the public to influence health policy and ensure the interests of physicians and patients are represented. Through these functions, the CNOM plays a vital role in maintaining the integrity of the medical profession in France, promoting ethical standards and ensuring high-quality care for patients.